Good morning. My name is William Pernik. I'm a criminal defense attorney and a certified specialist in criminal law by the State Bar of California. Today, I want to talk to you about a subject, and that has to do with intersection of criminal law and federal immigration enforcement. Specifically, when a person is a non-citizen and going through a pending misdemeanor or felony criminal matter, the outcome of that case could significantly impact a person's legal status in a country, leading them to get deported, denied re-entry to the country, prevent them from becoming naturalized, or achieving adjustment of status. In addition, due to recent changes in our administration, Immigration and Customs Enforcement has enacted a new policy, which is something that we think is going to significantly impact day-to-day administration of our justice system. Specifically, policy number 11072.3 now permits Immigration and Customs Enforcement agents to conduct civil immigration enforcement in or near courthouses. Civil immigration enforcement action under this policy is defined as any action taken by an ICE officer or agent to either apprehend, arrest, interview, or search any alien. This policy is completely separate from criminal immigration enforcement at or near the courthouses. Who are these aliens subject to this policy? Well, according to the memorandum that ICE sent out, ICE civil immigration enforcement in or near courthouses will include actions against targeted aliens, including, but not limited to, national security or public safety threats, specific aliens with criminal convictions. It does not define how serious those convictions must be. Gang members, aliens who have been ordered removed from the United States but have failed to depart, or number 5, aliens who have re-entered the country illegally after being removed. The policy goes on to state that other aliens encountered during this civil immigration enforcement action in or near the courthouse may include family members or friends accompanying the target alien to the court for their court appearances, or even serving as a witness in a proceeding. And those persons may also be subject to civil immigration enforcement. The policy does have a recommendation that ICE agents should, whenever possible, avoid conducting civil immigration enforcement actions at non-criminal courthouses or specialized courts, such as family law courts or small claims courts. This new policy is highly problematic to us as lawyers because these actions will undoubtedly have a chilling effect on people who are non-U.S. citizens who will be afraid to enter courthouses not only as criminal defendants, but also as victims and witnesses. If a person is a victim of sexual assault, if the person is a victim of domestic violence, the perpetrator may not even be an undocumented alien or an alien. And yet, if the victim belongs to this vulnerable population and they're now scared in court because they fear that they could be grabbed by ICE, that's going to create a highly undesirable impact on our administration of justice. You may also be a U.S. citizen who is pursuing a legal claim in court. Your claim may depend on a material witness who is a non-citizen and now afraid of immigration enforcement. Again, this is not limited to illegal aliens. This policy gives ICE agents discretion to go after any alien that they wish to interview, arrest, search, detain, or investigate. So what are some of the things that you can do if you or someone you know is not a U.S. citizen and has to appear in court either as a person charged with a crime or a witness or a victim of a crime? Number 1, failure to appear in court is a bad idea because if you fail to appear in court, a warrant could be issued for your arrest, assuming that you were ordered to appear either by the judge or by virtue of being served with a subpoena. You do not want to, as a general rule, to be arrested on a warrant because any custody type of situation will undoubtedly increase your risks of immigration enforcement. Number 2, you have to remember that California is presently in conflict with federal government when it comes to the topic of immigration enforcement. That's because in 2017, California enacted a law called California Values Act, which specifically restricts the use of local or state resources to cooperate with federal immigration enforcement. Under this law, California law enforcement agencies are specifically prohibited from cooperating with federal immigration authorities when it comes to investigation, detention, or arrest of persons solely for immigration purposes. Under this law, California law enforcement agencies are also restricted in their abilities to do the following things: honor transfer and notification requests, providing release information, such as when so-and-so is going to be released from custody, or allow the officers to be deputized by federal authorities for purposes of immigration enforcement. California state and local authorities are also prohibited from entering into contracts with the federal government in order to build or house detained persons solely for immigration purposes. Now, one of the things you might be wondering is, what should I do if I'm not a U.S. citizen and I have a pending criminal case, whether it's a misdemeanor or a felony? Should I be afraid to show up to court? Should I fail to appear and allow a warrant to be issued for my arrest? Should I even mention my immigration status to my lawyer? Please listen to the following, because it might provide you with really helpful guidance on what to do if you or someone you care about find themselves in this situation. Number one, please remember that even though this revised immigration and custom enforcement policy allows for civil immigration actions at or near courthouses, ICE still has a fundamental limitation when it comes to its manpower. They simply do not have enough officers and agents to conduct sweeps of each and every courthouse or to conduct this operation on a massive scale. That's number one. Number two, as a general principle, you do not want to fail to appear in court and have a warrant issued for your arrest. You're far better off discussing with your attorney or your public defender, if you do not have a private counsel, what alternative methods you have in order to satisfy your court obligations. In California, under Section 977, in most misdemeanor cases, and with court's permission, even in some felony cases, your attorney may be able to appear for you in court without you having to be present. That means, for most people, if you are charged with a minor offense, such as vandalism, property crime, petty theft, shoplifting, or even a DUI, you may be allowed to appear in court through your attorney, who could potentially handle your entire case and resolve your legal problems without you ever having to set foot in court. If your attorney is able to obtain authorization from the court to allow you to appear remotely, that will obviously minimize the risk of immigration and custom enforcement action affecting you or your family members. If you have loved ones who want to attend the court proceeding but are worried that they may come into contact with ICE agents, likewise, your attorney can request authorization for them to appear remotely. These requests will be considered on a case-by-case basis, depending on the rules of court in each of the jurisdictions that may be considering your request. Next, it's really important that you do not hide your immigration status from your attorney. Many times, as defense lawyers, we come into contact with clients who are, by all appearances, U.S. citizens. They have lived in this country for most of their lives. They speak fluent English without any accent. They have gone to school in this country. And we may have absolutely no idea that this person was not born in the United States, had American citizens as parents, or was naturalized. Therefore, if you do not inform your attorney that you are not a U.S. citizen, your attorney may make an assumption that you are a U.S. citizen and therefore fail to protect you from some of the adverse immigration consequences you might be facing. You do not have to worry that your attorney will disclose your immigration status in public and therefore make you a target of immigration enforcement action. Attorneys in California are actually prohibited from publicly disclosing someone's undocumented status. Therefore, even if you tell your attorney that you are in this country illegally, your attorney will not disclose it on the record in a way that's going to make you a target. On the contrary, California has special rules that all lawyers, being members of highly regulated profession, must follow. And these are rules that apply both to defense attorneys and to prosecutors who are dealing with clients or defendants who are non-U.S. citizens. Specifically, under Section 1016.3 of the Penal Code, defense lawyers are required to inquire and analyze their clients' specific immigration circumstances, and to provide a personalized advice, including consulting with immigration experts where appropriate. That means that if you are not a U.S. citizen facing a particular criminal charge, your attorney and you should have a discussion about what that might mean if you get convicted of a particular offense. Will that subject you to, for example, losing your ability to get naturalized if you're a lawful permanent resident? Will that result in your denial of adjustment of status? Will that put you at high risk of being deported or denied re-entry to the country if you were planning to leave the country to visit your family abroad. All of those things are really important to discuss with your lawyer because your lawyer has a specific legal obligation to seek an alternative resolution of your case based on specific immigration consequences that you might be facing. In the same time, under the same code section, 1016.3, prosecutors in California are also required to consider avoiding adverse immigration consequences for the same defendants who they prosecute. That's because under federal law, certain crimes might be considered to be much more serious, even when they're not considered as serious under California law, or vice versa. To give you one such example, a battery with serious bodily injury is considered a strike in the state of California and a serious felony offense. But for federal immigration purposes, a battery with serious bodily injury is considered to be less detrimental than some other charges that could be used or pled to in such incidents. Oftentimes, lawyers on state level will try to avoid a conviction for something known as a strike, something considered a serious or violent offense under California law. But it may be that in trying to avoid a strike conviction, your attorney could end up pleading you to something that could create far worse consequences for you in immigration court. So it's very important to have these discussions. Generally, the way your attorney will negotiate an immigration-neutral or immigration-friendly disposition of your case is by asking you pertinent information about your immigration status, consulting with an immigration expert, such as an attorney who specializes in immigration law, obtaining what we call a collateral consequence letter from that expert, and then submitting it to his local district attorney for their review and consideration. Different jurisdictions do it differently, but at least here on the Central Coast, the general practice is that your DA will either have a dedicated committee within their office who will consider immigration impact of a particular disposition in the case, or will personally consider it if their office does not have such set policy or established committee. The attorneys who will look at your case will then decide whether immigration impact on you will be disproportionate and unjust. They have a legal obligation to consider as one of the factors adverse consequences to you as an immigrant and non-citizen in deciding what a just resolution of the case may be. This is not something that's going to be used against you. In other words, DA cannot say that not only is your client committing this crime, but he's also here illegally, therefore I want a harsher sentence. That's certainly something that I'm used to hearing from years back before these laws went into effect, but they're prohibited from doing that today. Instead, the district attorney will consider whether some other charge that does not have the same effect should be offered to you in order to simultaneously achieve a just outcome in a criminal case here in California and avoid a disproportionate and unjust outcome to you in federal immigration court. At the end of the day, we want everyone to be aware that if you're not a citizen of the United States, times are really dangerous right now for you as an immigrant in this country. You want to take every step possible to avoid coming into our criminal justice system. You do not want to be on the radar of law enforcement or immigration and custom enforcement. If you're not in this country legally, they could theoretically contact you, question you, detain you, and deport you from this country. What that means for you if you're not a United States citizen and you have a pending legal matter is that you may become a suspect or a person of interest in a pending immigration and custom enforcement action, or if you're not careful with how you handle your criminal case, you could end up with a conviction that significantly affects what will happen to you in federal immigration court. Therefore, it's very important that you contact an experienced attorney who understands the delicate balance between protecting your rights in state court and avoiding aggressive and disproportionate impact on you and your family in federal immigration court. You need not be afraid. You just need to be smart. You need to be proactive. You need to understand what your rights are, what your responsibilities are, and to stay informed. If you are careful, if you are smart, and if you are prepared, we really hope that you can minimize the risk to you and to your loved ones based on the changes that are happening in our country today. I really hope you enjoyed watching this video. This video is not intended as a debate on propriety or impropriety of current immigration policies. We're simply commenting on the impact that these policies have on a population of clients in our communities. What we really want everyone to do is to be smart, to be informed, and to stay out of trouble. So please like, please subscribe, and leave us a comment. Thank you very much for watching.